Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in CV23 0280 Katenta v. Corona. We remind you that these proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible to watch the clock to reserve a portion for rebuttal if you'd like. Also, please keep in mind that we have read the briefs and conference the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honors. May it please the Court. My name is Al Arpad. I'm appearing for the appellant, Alexandra Corona. I'd like to reserve, let's say, 4-ish minutes toward the end for rebuttal or however long it takes. I went over the briefs, and I actually think they're mostly pretty good. They present the issues fairly. The main reason that I asked for oral argument in this case is because I'm asking you to bypass a recently published decision, and that's a big ask. So I wanted to make sure we had a good record on this. That's the Gellin decision. So I'll start with the hard issue, which is the interpretation of support prior to the filing of the petition going back 3 years under 25809, ARS 25809. Our argument has been that the first subsection of the statute, subsection A, says that the court shall direct subject to equitable defenses, and that the subject to equitable defenses is how much discretion the court has. I noticed in looking at the briefs that in discussing the Gellin decision, I hadn't addressed footnote 4 in the Gellin decision, which says that later in subsection A, it says, if any, it says, shall direct subject to equitable offenses the amount of child's back support, if any. And it says the if any is essentially the source of the discretion. I don't think that's a natural reading of that statute at all. The statute has set forth what is the amount of discretion. It's subject to equitable defenses. Reading the if any to create some additional discretion that doesn't otherwise exist in the statute does not make sense to me. The second reason that it gives in footnote 4 for the reading in the Gellin v. Murray case is that it's parallel to the way ARS 25320 works for child support. And I don't think the legislature, if you look at the history of those statutes, they come from completely different places. And the policy is different, and the likely circumstances are very different. In a dissolution situation, which is what ARS 25320 addresses, you've got not only the fact that the people were very likely living together, and so it says only if they were separated are you really going to be looking at back support, but you've got issues of their income's probably community by law. The idea that you're going to do 3 years or more of back support in a dissolution proceeding is much less likely, and therefore...
They could be legally separated.
Your Honor?
They could be legally separated.
They could be, but that's not going to be the majority of cases. So certainly
whether it's the majority of the cases or only a small minority of cases, it's still there, and it still references what would appear to be a discretionary call, correct?
Yes. Yeah, and I'm not here to argue that ARS 25320 doesn't give the court discretion. I think it does. But the circumstances, going back 50 or more years, the circumstances of a paternity action were almost always mom is seeking back support from dad. And so that's the very first thing that the statute deals with. Now, that statute's been rewritten multiple times, particularly the early 90s, and then renumbered into Title 25 to make it clear that it's a family court issue and not a civil action for just money. But that's the background of it, and I think that the legislature was entitled to assume that in the vast majority of those cases, there's going to be some issue of back support. And so the legislature could logically set a different standard for the judge there. Now, the judge has some discretion on equitable defenses, and I will criticize the Petro decision a little bit and say I think maybe their discussion of equitable defenses is a little bit too technical and old-fashioned. It doesn't have to be estoppel or something else that you could bring in the courts of equity in England in 1700. I think the most common equitable defense is probably I paid a bunch of the bills, which isn't a recognized equitable defense, but it's certainly equitable and it ought to be a defense.
Parties could have been living together.
Yes, absolutely. You've got a much wider diversity of situations. You've got a much wider diversity of circumstances. You've got the law recognizing that there can be a maternity action as well as a paternity action. So it certainly is different from what it was 50 years ago, but it's still that you're not going to have issues of everybody's income is community when you're dealing with this unmarried couple, which is by definition what we're dealing with. You're not going to have as often that they were living together and sharing expenses, but it certainly can come into play. And so I think the level of discretion that the legislature set here is appropriate and reasonable. And I thought that the Petro decision did a better job of keying in on that. And the fact that they used the word presumptive, I think a presumption is a fair description of shall direct subject to. That's subject to equitable defense. The decision, there is at least a presumption that this is...
Let me ask about that, because we're constrained, of course, as we should be, by the text of the statute, and the text of the statute doesn't use presumption, correct?
It also doesn't use the word discretion, but that is correct, yes.
So is it better sort of analytically to think of it maybe as a placeholder or beginning point or something like that as opposed to presumption that the statute, and again, statute doesn't use placeholder or beginning point either, but I get a little concerned given that presumptions can have, genuine technical meanings that can have ripples in a pond that here isn't always invoked, just given the nature of the statute.
I think particularly given the history here with Petro and Gellin and needing to figure out what you're going to rule on, avoiding the word presumption would be a good idea. Avoiding the word discretion, unless it's fairly well defined, is probably also a good idea. Another one I'll throw out there is I believe the Gellin decision, or the Gellin opinion, used the word, it said that subsection A authorizes an award of back support. I think it does more than authorize. It says shall direct. So that's kind of my second point I wanted to get to after talking a little bit about footnote 4, is that I think at the very, very least, subsection A of the statute says that the court has to make a decision. The court has to address it. The court can't sidestep it like it did in this case by saying you didn't raise it and therefore I'm not doing it. And it's a little bit colloquial, but I think that's a fair description of what the court did in this case.
Counsel, are you saying then that 809A can never be waived?
It could possibly be waived. I can't take an absolute position on it because it's not in front of me and I don't want to argue somebody else's case. I think it could possibly be waived, and it was held in some of the older cases going back to different versions of the statute, if it had never been raised at all. So if she never asked for child support in back support in the complaint and never asked for it in the pretrial statement, maybe you could say, you clearly waived this, I'm not going back and addressing it. I'm not even sure it applies in that situation, because the very first line in the statute says, the court shall direct subject to equitable defense.
And you're right. But there are a lot of statutes that say things like that, and I don't think that technical language means it can never be waived by a party, that a court constantly has to be vigilant to sua sponte raise it. And I understand your point that that's not this case, but when you say, A says the court sort of has to perhaps always do that, that slows me down a little bit.
I can understand that, but I think there are, two responses. One is that the consequences of it not being clearly raised and the court not addressing it is that you're going to have a handful of appeals where somebody realized within the time to appeal that they didn't get what they were entitled to. So it's not like this is going to open the floodgates to a million cases saying, hey, I want to start all over again from scratch. I said I was going to make 2 points, and I forgot the other one now. But at any rate, at a minimum, I think the statute means that the court has to make a determination. And so again, if they never asked for it and they never realized they didn't get it, and a year later they come back and read the statute and say, I didn't get it, that's not going to be a void judgment. But if they go look at the statute and realize they didn't get what they were entitled to, they're probably entitled to appeal it and at least ask you whether it was a waiver or not. And the second point I was going to make, which I brought myself back to, is the Simpson case. In this particular context, it's relatively hard to waive your rights to the back support. That in that situation, it said at least for 25320A and at least for the period post-petition, you couldn't really waive it. The court had to deal with it one way or the other. Now, again, this maybe is distinguishable, but I think it's hard. And given that my client did, in fact, ask for it in both the response to the petition and in the pretrial statement, I don't think she waived it. And I think it's very difficult in this situation for somebody to waive correct application of the law. Waive the entire issue is one thing, but waiving correct application of the law, I think you should be able to either file your motion for reconsideration, file your post-trial motion, whatever you call it now, or do an appeal if you didn't get what the statute says you're entitled to.
Did your client present any evidence during the evidentiary portion about what specific expenses she may or may not have had in the period prior to the filing of the petition?
The traditional version of this statute...
Calls for yes or no.
I can't think of any.
Okay. Because that's the way I read it when the judge reviewed your record. He said, you didn't present anything. You didn't present any evidence that would have dealt with the pre-petition period, specifically as it raised your expenses and why you'd be entitled to this past support.
Well, but past support isn't primarily based on expenses, it's based on income. And there was lots of evidence about income. And so father raised in his answering brief, she didn't prove she needed it. That's really not the standard that gets applied here at all.
Was there any evidence about both parents contributing to the child's needs during?
There was some very offhand discussion. It wasn't specific at all, and I don't think even father was claiming that he was making any kind of regular payments beyond paying for a few incidental things here and there. I'm sure Mr. Murray will correct me if I'm wrong about that, but that's certainly the gist of what I got out of it, that the discussion of expenses and who was paying for what was vague at best. So in this situation, well, the second part of it, of the appeal is the calculation of child support from the petition up to the time of the judgment, and I think that one's pretty clear cut. We're taking the position that the court really didn't have evidence to support the number that it used, which was the number that had been set way back at the beginning. The court never really made a finding that that was credible, never really made a finding that that was the gentleman's income. It was, and it wasn't consistent with what the court found after a full trial discussing what his income had been.
Did the court provide, in ruling on the temporary orders, did the court avail itself of child support worksheets during that period of time?
Yes, it did produce a child support worksheet, so I don't know whether that legally rises to the level of a finding, but he certainly did write in a number that was based on something that the father had said very briefly at the hearing. So there is a number.
And my understanding is that that number is different than what the trial court used for the final worksheet.
Yes, it's not quite as low as what father was arguing for at the final hearing, but it's significantly lower than what he used for the final worksheet.
Were there any other changes to the worksheet from the temporary orders to the final?
Yes, and that was my second point that's kind of critical. Even if you disagree with me and you think that the judge entirely was within his discretion to use the earlier number, I don't agree with that, but even if you do, there's a change in parenting time.
It decreased, or it increased?
It decreased fairly significantly. And the judge knew about that, and it was an issue that had been raised, and it was the same judge throughout. So it's not really possible to say she waived that either, I don't think. So at a minimum, this has to get sent back for a proper worksheet for that interim time period. And Father, I think, even admitted in his response that he wasn't doing equal parenting time for a portion of the pretrial period.
So if it goes back, on that to recalculate, the child support guidelines changed, I think, between the temporary orders and the final.
I think that's true. They would be the same ones used in the final.
In the final, under the statute, the court would have to use the current child support guidelines to go back and recalculate the retroactive.
I honestly don't know if that's true. That's something I'm going to have to leave to the trial court. I wouldn't think that number isn't a huge number, but it's a number that it's a very clear error. It ought to be corrected, and if you're correcting it, that would be a good opportunity to ask the trial court to clarify, did you really mean that this was a good number and that you believed his testimony?
What's a good number, the attributed income
the
or
first
the final?
attributed income, the temporary attributed income. Did you really, after what happened in the trial and after what you said about Father's income and his credibility, did you really think that was still a good number, and did you really therefore intend to say, yes, that's the number that should be used throughout the proceedings? And I think you need to send it back at an absolute minimum for the court to say, did it intend to make a determination, to direct the amount, if any, that is going to be done. The court needs to look at the evidence, because there was evidence. It was not a case of no evidence. There was lots of evidence, and the evidence that the court actually used to set the number was from 2019, the decision of the other court. So you can't say there's no evidence of what his income was. So therefore, based on the statute, what is the back child support? And if the judge says it's zero, perhaps we have another appeal about Yellen. But at a minimum, I think you have to do that. We're entitled to a determination under the statute. And I'll reserve the rest of my time, if I may.
Thank you, counsel.
Good morning, Your Honors. Stanley David Murray on behalf of the appellee, Buzinga Katenta, who was the petitioner in the lower court proceedings. As I understand the appellant's opening brief, the main issue that they want to bring before you is that the trial judge did not comply with 25809. The trial judge did. We have an order of child support, temporary order, but it is an order of child support. So child support has been established under 809. There's nothing in the statute, 809, that requires the judge to go back now that we've had a final trial and revisit and recalculate the original determination.
Sure, the statute on a temporary order specifically says that when you enter a final order, the temporary order is vacated. So there was, and doesn't the statute also say that after the enter of a final order, it goes to the first of the month after commencement of the proceedings?
The child support order?
Yeah.
Yes, sir, it does.
Okay, so if the temporary order is vacated, and the statute specifically says you're supposed to go back to the first of the month after commencement of the proceedings to enter the order, and you're supposed to apply the current version of the child support guidelines, was that done in this case?
No, sir, it wasn't, because the child support order that was established under 809 was not modified subsequently. The trial judge had the discretion to keep that same temporary order in effect, and that's what you saw in the Gellin case. There was a temporary order in the Gellin case, and the court reinstated it.
That wasn't an issue in Gellin, was it?
No, but it was in the facts.
Yeah, well, I mean,
So
if the parties agreed to, I believe it's over $1,000 a month in child support under the temporary order, and the court entered a full judgment for the temporary orders, and that was never challenged. How does that lend support for your argument?
It's an example of when the retroactive award was not modified.
Was it changed in Gellin? Did the final order of child support in Gellin change? So if there was,
Guess so.
pardon me?
I guess so, because...
No,
it's a different
the answer
number.
would be no, it didn't. And so the temporary order simply became the final order.
Well, that's true, and that kind of supports our case here.
Excuse me? Your final order was nowhere close to what the temporary order was.
No, but the temporary order wasn't changed. It wasn't retroactively modified. See, 809 establishes child support. It doesn't modify it. In fact, if
Mr.
you
Mike,
want
I have another question I'd like to ask you.
Yes, sir.
And I don't mean to dominate, so I'm going to add. Was there anything in the record that would indicate that there was a change in income during the period of time when the temporary order was in place until the final order?
Yes, there was a change of income.
Could you direct me to that, please?
Well, they testified they didn't submit AFIs at the temporary orders. And so my client testified he made about 45.
And that was rejected by the
55,000.
trial court.
Well, it was accepted in the temporary orders.
Okay, it was rejected by the trial court after he heard a full-blown hearing.
Yes, sir, because he...
And he
relied
found
on
an
that.
attributed income.
Yes.
All right. And is there anything that would indicate a change, because he maintained that at the temporary orders and he maintained that at the final order, and it was rejected? So my question to you, he didn't get a new job, he didn't get, win an award, he didn't win anything that would indicate an increase in income that would justify the final order over the temporary order.
Correct. So, again, because 809 established what the child support was at the temporary order, the burden was on the mother to ask for modification retroactively, because 809 has already established child support, and it was only $121 a month, and I understand there's an issue about the income and an issue about the parenting time. But it was up to mother to either file a petition to modify, which 25809E requires, or else at the trial show the different circumstances that existed from the time of the temporary orders to the time of trial. And she did not do that. So 809E was complied with, 809A and B were complied with by the trial court when it made the temporary orders finding. And so the subsequent order at the final trial was not made retroactively because mother did not specifically request that. The final order...
Counsel, if on the motion for reconsideration, if the court had not applied the temporary child support award retroactive back a few months, would that have been error?
If it back a few months?
So the child support order, the temporary order went into effect in August 2021, I think.
Oh, yes, sir.
And on the motion for reconsideration, the court applied that temporary order retroactive 3 months to the commencement of the paternity proceeding, correct?
Right.
So is it your position is the court was obligated to do that under 809,
Yes, sir.
but where you're reading 809 differently is you don't read 809 to say that the final child support award had to go back to the commencement of the proceeding.
Yes, sir. That's correct. And again, once that temporary order was entered, child support was established under 809. So it was up to mother to request a modification, or at least introduce evidence at trial as to why that temporary order was inadequate for that retroactive application.
So let me read to you 25809A.
Yes, sir.
And you tell me where I'm reading this incorrectly. So it says, after parentage is established, the court shall direct, using a retroactive application of child support guidelines. So we're talking about the final child support guideline or child support award established, correct? After parentage is established, the court shall direct, using a retroactive application of the child support guidelines, the amount which the defendant shall pay for past support of the child, the manner, I'm quoting the wrong
89B or
statute.
89A?
Sorry. Give me 1 second here. Here we go.
Is that 89B?
No, the court, you're right, 89B. The court shall enter an order for support determined to be due for the period between the commencement of the proceeding and the date that current child support is ordered to begin, correct?
Yes, sir.
So help me walk through, because as I read that, it's talking about the final child support award
No.
going back to the commencement of the proceeding.
I
You're
believe it's
reading that
talking about-
differently.
I didn't want to interrupt you.
Go
I'm
ahead,
sorry.
go ahead.
I was just going to say, it's not talking about the final order being retroactive. It's talking about an order for child support being retroactive. That's what the temporary order did. We don't need to come back to 809A or B because the temporary order did that. Remember, the court made it retroactive to May 1st, 2022, or 2021, excuse me. So now that the current order is in effect, it's effective December of 2022, because that's the evidence that was submitted, and there was no request, or no evidence, rather, for the retroactive award to be changed.
So what you're saying is that you believe the temporary order in this case became a final order because you believe it needed to be modified under a modification petition.
Yes, sir.
But that means the plaintiffs would be prejudiced, or anyone would be prejudiced at a temporary orders hearing if they don't put on all of their evidence at a temporary orders hearing. And I thought the law was pretty clear that no party is prejudiced by a temporary order because we're going to resolve it all at the final hearing.
Yes, sir. If they don't like the temporary order, they can modify it. They can request to modify it before the final order. They can also...
But it's still a temporary order that's still non-prejudicial to the party, to the parties. It's both. It can apply both ways. Until you get to the final hearing that's where we expect you to present all your evidence.
Correct. And that's the
Because
second...
aren't, like, temporary orders are truncated in Maricopa County.
Oh,
So what, you
sure.
got 2 minutes
But that's the
to
main
present
point.
your evidence?
There's no requirement that temporary order has to be revisited under 809.
Well, other than the statute specifically says it's to be terminate once the final order is entered.
That's correct, but just because it's terminated at the final order doesn't mean that retroactive has to be made. There's no... The temporary order, it has some binding effect. I mean, ask the person who's got his wages garnished with the income withholding order, or if she or she...
Didn't we say that? Yeah, but if it was inappropriate at a final order, the court has to compensate the person for the inappropriate garnishment of the wages that previously happened. And they don't have to wait until the child's 18 either to do that.
Well, in the decree, you can put an order enforcing temporary orders. Even though they terminate at the decree, it's up to the party who had those temporary orders to enforce them in the decree.
Well, and I'm
So,
assuming,
they still
counsel,
exist.
that would be appropriate if there was no change in circumstances. And so that the final child support guideline amount was identical, like it was in Gellin, to the temporary order.
And that's my point about the change of circumstances that mother should have raised if she didn't like the temporary orders being retroactive. So I guess we're going around in circles here, but I wanted to emphasize that temporary order is an 809 order. It established child support, and it was up to mother to modify it so that the final order was made retroactive, and she didn't ask for that, didn't present evidence of that. The other point that Mr. Arpad raises is the mandatory nature of the 3-year period. I think this Gellin court case is pretty clear on that. First of all, it technically overruled the Petro case, but it did go through the statutory construction and showed, based on prior case history, that discretionary has always been the standard for that 3-year period. And again, at the trial, mother did not present any evidence of the circumstances existing 3 years prior to the filing of that petition for modification, for establishment of child support. And by the way, it's my client who filed that petition for child support. Mother never challenged it. She never presented evidence showing that the temporary order was inadequate or didn't meet her needs. She didn't show any expenses for that 3-year period. So the court was correct in denying the retroactivity to that 3 years prior to the filing of the petition. As far as the calculation of the father's income, Yes, the trial court has discretion on that, and I think the appellant is asking this court basically to reweigh the evidence. Mother submitted the evidence of the other court case that established father's income at $7,000 a month, so the court accepted that as being more credible than the $12,500 that mother was asking for as his income versus the $3,000 that father said his income was. So again, that's a discretionary ruling, and again, this court defers to the trial court when it comes to credibility and to the weighing of evidence.
Counsel, and I'm a little slow on the uptake. I want to move back to 809 for a minute, if we could.
Certainly.
So your point is, hey, when we've got the support order entered, if nothing happens, it stays in effect for the temporary stage, stays in effect forever. Is that fair?
As a determination of the retroactivity, yes, sir.
Okay. What if the final judgment after a hearing doesn't mention that order?
That would be error then,
Tell me why.
because there's been a determination of child support.
Right, but your point is that can't be changed unless there's a motion or petition to modify. So it would, in other words, are you saying that the final, after we're talking about temporary orders, what happens to a temporary order when following a trial the ultimate judgment is entered, and that judgment doesn't mention the temporary order on child support?
Well, that would be an error because 809 requires a retroactive award back to the date of filing. And the temporary order is that child support order. I guess what I'm trying to clarify is that even though it's called a temporary order, it's a child support order.
Well, and I understand that. And what you're talking about is sort of bridges a continuum between what I would call a pure temporary order that is not appealable, is not a final judgment, and then a final judgment. And you're sort of putting this type of temporary order under 809, which is sort of an odd lot statute anyhow in the context of Title 25, as somewhere in between those two. And that's what I'm trying to better understand, including that the title of the statute, after all, is judgment, right? You're not claiming that a temporary order for child support under 809 is a judgment, are you?
Yes, I guess I am, because it established child support at the time that the petition was filed, or within that framework, based on the evidence that was presented.
Mr. Mayor, I'd like to ask you a hypothetical that follows up on what Judge Thumb is asking you. So if the court issues a temporary order, and we'll say the husband doesn't pay it, doesn't pay the temporary order, and then a year later when it gets around to entering a final judgment, finds that no child support is owed, can the mother collect on the temporary order that was previously entered?
No.
Right, because
The decree
it goes away.
Right.
The temporary order goes away
Correct.
when the final judgment is entered. So when the final judgment was entered, in this case, the temporary orders go away, and the court is obligated to issue, applying the child support guidelines back to the first of the month after commencement of the proceedings.
I disagree, because the order was entered and enforced in the final orders that the trial court made. I believe the trial court has discretion whether it wants to keep the temporary orders in effect or not. They terminate in the decree unless the decree says otherwise, correct? And that's why you can enforce those temporary orders. So I guess my point is that there was a child support order here, and the trial judge decided to keep it because mother did not challenge it. Yes, it was applied retroactively to May 1st, which was the first full month after the petition for child support was filed. We can't just ignore it. It seems to me that this is a judgment that's enforceable in the decree. If mother didn't collect any of that money, she could certainly come to the court and say, hey, make him pay the temporary orders that you made. And look at the situation in regard to a hypothetical, Your Honor. Let's suppose there was this temporary order. Let's suppose mother modified it and got another temporary order for child support. And then we had this final trial where the judge makes a decision on current support. Does this judge have to go back now and say, And you know how family court judges are so busy. He's got to go back and recalculate the amount that he made in the temporary order on the modification hearing. Does he have to go back to the temporary order that he made on the initial hearing? I don't think that's what 809 requires. 809 simply requires a child support order, and that's what we had here.
Counsel, two quick questions. One, I know you're arguing that the temporary order was an order under 25809, but 25817 is the temporary orders statute, correct?
For fraternity cases.
Right, okay. Pivoting, another question on attorney's fees. Based on the court's finding, the court attributed, I think, $7,000 and change to father, $4,000 and change to mother, but found no disparity of income. Talk to me on that, how that's not disparity of income.
Well, under the interpretations of 25324, well, in this case it would be 809, you don't have to prevail on both factors. The court can award attorney's fees based on either reasonableness or financial disparity. And in this case, the court decided it on reasonableness, finding both parties were unreasonable. So I believe that's justified under the law.
Under the reasonableness, but if it was just, I know the court can consider both.
Yes, sir.
But if I'm just looking at the lens, if I take issue with the disparity of income,
There is a
that close?
disparity.
Is that close enough to not be a disparity of income? That's $7,000 a month compared to $4,000 a month.
Yeah, I don't know if there's any particular guideline on that, Your Honor, but 7,000 versus 4,000, especially when the 7,000 is attributed, I don't see that as a significant disparity. And it's not just income either; it's assets and family loans and stuff like that comes into the equation. I'm down to 51 seconds, unless the court has any other questions.
Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Arpad, you have a little over 3.5 minutes for rebuttal.
Thank you, Your Honors. Interesting and mind-expanding points about exactly the technical relationship between the temporary orders and the final orders. The way this went to trial was mother was asking for back child support both after and before the filing of the petition, so it certainly was at issue. I don't think you're required to file a separate petition on that, and I don't think it would be wise to require you to file a separate petition on that. And what the statute says then is that the trial court has to set a statutorily compliant amount of child support, and so that applies backwards and forwards. And so the question is not so much was it set in a temporary order and then it's there unless you sufficiently challenge it. It is in a different case, the trial court could very well say, I agree with the number I originally found, but things have changed over the course of a year or two. That's really not what happened here at all. The trial court found a very different number, found father not credible at the end of it, and his income certainly seemed to vary quite a bit, but there was no real basis to decide what it was, so the court defaulted back to a 2019 judgment against father, and it's very hard for me to see that that's any kind of a basis to say, yeah, he was probably making this. I mean, I've litigated cases in front of this court where there's better evidence of what people were actually making at different times, and the court decided, yeah, that has to be segmented. You got to go back, you got to figure it out for this time period, you got to figure it out for this time period, you got to figure it out for this time period. That's kind of not this case because the evidence was so up in the air about, and as Mr. Murray said, father's income ended up being attributed. I just don't see any justification, and I don't see that the trial court ever even really said, I'm finding this a number credible and therefore I'm sticking with it. I think the trial court just didn't want to do the back child support, and that's what he said. He said, you didn't present any evidence, and he's wrong about that. There was as much evidence of that as there was of anything in the case, and therefore I'm not going to deal with it. The critical thing, setting the procedural issues aside, is that the award needs to be compliant with the child support statutes, and the 25809 is clear on that. Again, I will just emphasize that the primary evidence that the trial court ended up finding credible was the prior child support ruling, which was from 2019, which was well before the petition was even filed here. So to the extent it's relevant in 2022, it's probably relevant in 2021, 2020, 2019. It's hard to say that there's no evidence in that situation. I just can't see it. And I don't think that's what I don't even necessarily think the trial court was thinking about that. I think the trial court just said, I'm not dealing with it because I don't think you raised it. And they was wrong.
Thank you, counsel. Thank you both for your briefing and for your arguments. We'll take the matter under advisement, issue ruling in due course. We'll be in recess to allow the next argument to set up. Thank you.